Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, OraSure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics.
Hello and welcome back for another session of Day with DISA. Today we're joined by Pamela Devata, partner at Seyfarth Shaw, for a background screening industry update session. Pam, how are you doing today?
I'm doing great, Thomas. How are you?
Doing good. Glad to dive into another informative session. But before we jump into that presentation, I want to remind everyone of a couple quick things. If you have any questions, use the Q&A button at the bottom right of the player. Any questions we're unable to answer today, we'll reach back out to you after Day with DISA. Additionally, we'll make a copy of this presentation available for download on the Materials tab as we wrap up the session. With that being said, Pam, the floor is yours.
Great. Thanks so much, everyone. And I'm so happy to be here with Day with DISA again for another session to talk a little bit about some of the background screening updates that have been happening over the last year and what's been going on in the industry. All right, let's go ahead and get started. Before we do, obviously, everyone should know that I am a lawyer. Don't hold that against me. But everything we say today should not be construed as legal advice or counsel. I'm going to be giving some informational updates about what's going on in the industry. We are going to try and get to some questions from audience members. But please understand when you ask those questions, try not to have factually specific information. It protects you and it protects me. And again, nothing that we say here today is going to be giving legal advice or counsel. All right, let's go ahead and dig in. Today, we're going to talk a little bit about what's going on in the world of background screening as it relates to access of information. And so what we're seeing is sort of a trend in the industry about information you can get, information you can't get, and what really you can do as an employer when there is limitations to information and some options that you might have. We're also then going to talk about some recent ban-the-box legislation and some changes into that adverse action process. For those of you who have been going along with Day with DISA and going to some of the other sessions, Eden Hutchinson had provided a session a few days ago on adverse action. I provided a session also on background screening, sort of back to basics, where we talked about disclosure and authorization forms and the adverse action process. We're going to talk a little bit more about some of the nuanced new rules and new regulations, statutes that have come down that are going to affect that adverse action process. One of them just actually got passed in the end of December. So, hot off the presses in Gainesville, Florida. So we're going to be talking about that as well. So without further ado, let's go ahead and dive in. What you may have seen is over the last couple of years, there has been truly a movement, if you will, in the background screening industry and really in the court system industry about privacy. So there's been a lot of regulations and statutes protecting privacy of individuals and specifically protecting consumer privacy. You may say, well, what does that have to do with the access to records? Well, what we're seeing is obviously when you're running background checks, whether it be for an employment purpose or any other purpose under the law, right, you have to follow certain regulations and certain protections. These are because these statutes are consumer protection statutes. Well, what's happening is the court records, specifically as it relates to criminal history information, more often than anything else, although a little bit as it relates to driving records. But more often than not, what we're seeing is access to court records of criminal history information are being limited. And so what that means is you've got certain jurisdictions around the country that are that are restricting access to the information. So they might be doing things like restricting access to information of dates of birth or information to other PII, personal identifiable information. So what that means is when your background screening company actually goes and tries to get information about your candidate, they may have a harder time matching up the information that's in the public record of whether it belongs to your candidate or not. There may also be limitations of how much information they have going back a certain period of time. So what are we seeing? And we've seen this now for many years. We talked a little bit about this last year, but there's been some updates. And that's why we want to talk about a little bit more today. We're seeing certain counties, specifically in California, LA County, Riverside County, some other counties that are restricting access to only certain information. So for example, you might have access only to a year and a month, but you don't have the date, the actual day in a date of birth. Or you might have restricted access to driver's license information, or other information may be restricted. We're seeing that over in South Carolina, for example, that there's only access, you can only get a year of birth and maybe not a month or a day in certain jurisdictions. You're seeing this in Michigan, restricting access to certain minimal information. Now, here's the good news in Michigan. There was a lot of lobbying efforts, and I'm very pleased to say that there is now a process by which consumer reporting agencies, or really anyone who wants to go into the court system, can actually go and register to become an authorized user, and they must show that there's consent from the consumer to actually access that information. The good news is the Federal Fair Credit Reporting Act and many state laws already require consent. So there's less of a concern in Michigan than there used to be, again, much to the great efforts, both lobbying and other efforts and people in the background screening industry, and different association groups that worked really hard to make sure that access was still granted. But what that means, though, is there may be a delay in the information that, for example, you may be able to get. So there may be slower time frame to complete a background check, or longer wait time for a background check to actually be completed. It might be that certain searches or certain jurisdictions may be off limits, or there may be the ability to not run those searches. And what I mean by that is some background screening companies may say that those are unperformable, or there may be limitations in terms of the types of services that you're actually, as an employer, able to access. So what do, right? Because if you are an employer, right, you're running background checks generally because you're trying to ensure the safety and the security of your individuals, right? So you generally are going to run pre-employment background checks so that you are checking out the individual before they have access to your property, to your people, to your customers. You may also be running concurrent background checks during their employment, or some type of annual motor vehicle record check, for example. Not all industries do this, but many do. So what's the issue, and what do you need to think about if you cannot have access to this information? One might be, do you stop running searches in these counties? If anyone came to the session earlier this week, what we were talking about was, New York City and part of the process and the limitations that, New York City now has a bifurcated process, and you can only ask about criminal history after you've really vetted absolutely everything else. So, similar to that analysis, a lot of companies who have employees or applicants in New York City are saying, well, do we even run education verification or employment verification or drug tests, for example, or do we just only run criminal history so we don't have to have a two-step bifurcated process? If you want more information about that issue, please feel free to reach out to DISA and or to myself, and we can get you more information. But similarly, that's the sort of question. Do you not even run searches in these counties? Or if you are, if you are a regulated company, so you have to get this information, or if you have contractual obligations, right? Maybe you are a staffing company and you have specific obligations that you must get certain criminal history prior to placing someone. Or frankly, you just want to do so because you're trying to protect your company and you really feel like you want a comprehensive background check. Another thing that a lot of companies are doing is getting self-disclosed criminal history. And there's a way to do that. There's sort of two ways to do that. We talked a little bit about this in my earlier session, which is, should you even ask about criminal history? And of course, you have to ask a legally appropriate question at a legally appropriate time. Generally speaking, that's only going to be for most jurisdictions. And if you want a one size fits all, after conditional offer of employment is given. But that's an opportunity for you to ask the individual to self-disclose information. So perhaps you may not be able to verify that information at the county record. Maybe you will, but it may be that it's in a jurisdiction that has restricted access to information, or it's going to take quite a long period of time or be cost prohibitive. In that case, if you ask about that, at least you've done your due diligence to get that information. Now, could someone falsify? Of course, which is why you run the background check as well. And you don't only ask about self-disclosed, but it's another sort of belt and suspenders opportunity. A large majority of companies with whom we work ask that question to everyone, right? So they ask that question to everyone after conditional offer of employment. The other alternative, though, is to not ask everyone, but to ask targeted individuals. So for example, and you have to be careful because you don't want a discrimination claim, but let's say you have a background check report and certain counties cannot be performed because of the restriction of information that they're giving access to. So if there's an unperformable search, for example, maybe you say, all right, individual, please certify that you have never had a criminal conviction or haven't had a conviction in the last 7 years, or misdemeanor or felony, whatever you're searching for in terms of job relatedness, and in this specific county. So certify that you've not had a conviction in a certain time frame in Riverside County, for example. We've seen both. And it really depends on your own processes about what you want to do in terms of that. That's the additional certification, if you will, if these are unperformable as well. The other thing that we're seeing is that in certain jurisdictions, the courts are allowing consumers to get what I'll call a no record report. And so the consumers themselves can actually go into a court and get a certification from the clerk of the court in certain places that say, the clerk is saying and the court is saying, this individual has no criminal records in this court. That's another way that you at least have some protection down the road if there's a negligent hiring or negligent retention claim, or someone says you didn't do a full and comprehensive background check, that you can say, no, indeed we did. And where we couldn't get access to information, we got a certification from the candidate, and or we got a certification from the court through the candidate as well. It's a little bit more of a burdensome process and not the best user experience, but depending on your regulations and how much you must get, it's an idea where that's an other alternative when you are faced with a large population, for example, in a jurisdiction where you can't get information. Again, the reason why we're talking about this is the risk of negligent hiring and negligent retention. So what we're seeing is, and we're not seeing a lot of these, but one can sink a company, right? We're seeing a situation where there's reputational risk, and or there's another potential argument that someone on whom you've tried to run a background check, but you couldn't get certain information, and you didn't do these other options, then engages in some behavior that causes harm to a person or the company. So it could be theft or fraud, or it could be some violent behavior. And now you get a negligent retention or negligent hiring claim from the person or someone who's been harmed. And so in that situation, you want to have fodder to say, no, we were reasonable in what we did. We were reasonable in the checks that we were running. And when we couldn't get certain information, we were reasonable in the other alternatives that we did. It's tremendously important that you understand what information you're getting, what information you're not, and that as a company, the people who are reviewing the background checks, and whether you have a centralized process or a non-centralized process, anyone who is looking at a background check, number one, is looking at it and seeing the results and understanding perhaps when there was an inability to get information. That's going to be really crucial to understand that limitation, and so you understand to reduce your risk. The other thing I would just say before we move on to the next topic is there is a lot of a lot of things in the works through associations in terms of lobbying, proposed legislation, amicus briefs, and other items that the industry as a whole is really working on in terms of background screening to try and get more access to this information. But again, it's the rub of privacy versus the need to have this information. And it's really educating the court systems to understand that this type of information should be allowable for access specifically for background screening companies when you're dealing with employment purposes or tenant screening purposes or other permissible purposes under the Fair Credit Reporting Act for like a legitimate business purpose, site access, when someone needs to have this information. Okay, the next update that we're going to go to is some ban the box updates and some specific state and local jurisdictions that if you are operating and have either employees or applicants in these jurisdictions that you're really going to want to make sure that you are up to date on. This is hot off the presses. This was just passed in late December of 2022, just a couple of weeks ago. This is if you have any employees in Gainesville, Florida. It applies to private employers. This is the first private employer statute that we've seen in Florida. It applies if you have 15 or more employees. Be careful because it may not only be 15 more employees in Gainesville. You may have a couple of employees in Gainesville, but if you have 15 or more employees, generally you want to take a look and see if it's applicable. But the key on this one is if you've got operations in Gainesville or if you have hiring in Gainesville, you're not going to be allowed to ask about criminal history until conditional offer of employment. And if you do ask, it can only be convictions or pending records. You cannot ask about arrest records. Very, very similar to a lot of the other legislation in terms of ban the box statutes that are already out there. So if you have a one size fits all, you shouldn't be asking about criminal history until after conditional offer. You really shouldn't be asking about arrest records, given the EEOC criminal history guidance and very specific limitations on asking about arrest records throughout the country as well. Gainesville ordinance also now says you must conduct an individualized assessment. Again, if you listen to our presentation a couple of days ago, we talked about the EEOC criminal history guidance from a few years ago, many years ago now. It's still in force in effect. It's not a law or regulation. However, it is guidance from your regulator who is regulating discrimination claims. So it's important that you want to follow that. So you must conduct an individualized assessment. You must also, and this is the big key and the big sea change. So if you are having activities, you really want to make sure that you update your adverse action notice. You must now include a statement that the person has a right to file a complaint with the Office of Equity and Inclusion in that adverse action notice. This is very similar to some changes that we're going to talk about that went into effect in the last year as it relates to Illinois. And other jurisdictions now have notations where you must tell the person that they have additional rights to file a charge of discrimination or to file some sort of notice if they believe that they have been wronged. And you actually have to affirmatively tell the person. The damages are a civil penalty. So it's not a private right of action, but there is a civil penalty. And we're going to talk a little bit about at the end of our presentation what we're seeing in terms of enforcement. Because we are actually seeing quite a bit of enforcement pick up. We saw an increase in like 2019, a little bit of a decrease in 2020, 21, even 22 because of COVID. You know, frankly, the regulators, as well as some of the other enforcement agencies were really very, very busy dealing with the pandemic. Now that that has calmed down to some extent, we're seeing more enforcement pick up. So we'll go to the next update, which is Illinois. This one has been around a little bit longer, but I have to tell you, we are constantly seeing companies get this wrong. And so I wanted to keep it on here, not really as an update, but as a reminder that Illinois now, and this is the whole state, has a heightened standard for job relatedness. And so it used to be that there were other jurisdictions like Wisconsin, for example, that had a substantial job relatedness issue and requirement. Now Illinois has one. This was in 2021, but a lot of companies are not doing this. So it's worth a reminder. the heightened standard now is that if you are an employer in Illinois, before you can take action based in whole or in part on criminal history, there must be either a substantial relationship between the criminal history and the employment sought or held, or there must be an unreasonable risk to property or the safety or welfare or specific individuals or the general public based on that criminal history. What's required is, obviously, you have to do an individualized assessment and provide an analysis regarding job relatedness. What does that mean? It means you actually have to tell the person why the conviction is job related in your opinion, and you have to put it in the pre-adverse and the adverse notices. So you can't just do the analysis, you actually have to tell the person. Very similar to what we're seeing in other jurisdictions that have been around for a while, New York Fair Chance Act, LA Fair Chance Act, and some other requirements, but Illinois requires this now. And again, like I mentioned before, similar to Gainesville, you have to advise the individual of the right to file a complaint with the Illinois Department of Human Rights. So the takeaway here is you need to make sure that if you have not updated your adverse action notices, you need to go ahead and do that in short order. These are constantly changing. We recommended in our last session that we talk about updating your disclosure and authorization forms on at least an annual basis. I would highly encourage you and reiterate to also do that for your pre-adverse and adverse action letters, and or to ensure that you're not just following the federal law, but if there are state law inserts or extra jurisdictional requirements, that you are looking at those and making sure that if your background screening company is helping you send those out, that you're providing them the correct templates and or are going through the process to make sure that those correct letters are being sent out. We also get the question oftentimes about, can you send a federal letter and then send an additional follow-up letter? And the answer is it really depends. In some jurisdictions, it's perfectly appropriate to do so. I am a big proponent of the less letters that you have to send, the better, because there's just room for error. And so, sending a letter that is really customized, one pre-adverse action letter that is customized with the jurisdictional requirements that you have to have is generally recommended, although there are options, and certainly there are opportunities where that's not going to be the case, and you're still going to be compliant with the law. So it really depends on a lot of different factors, but the fact remains, you must make sure that you understand where the person lives, where the person works or will be working, such that you can have the appropriate jurisdictional information in those letters, so that you don't subject yourself to either a discrimination complaint, either at the state or jurisdictional level, or with the EEOC, or an FCRA class action, or another class action under one of the state analogs. In addition to the federal FCRA, there's about 14 states that have their own state FCRA type statutes that have requirements as well. All right, let's talk now about New York City. And I mentioned before, frankly, we could do an entire webinar, and have before many times, on New York City. I've added some updates here because while this was amended in July of 2021, the New York Fair Chance Act has been around longer than that, but we've actually seen even more focus on this than we have in the past few years. So, we had an analysis that was done sort of prior to July 2021. Then we had these amendments in July of 2021, and to make very, very clear that independent contractors are covered. And now we've got more enforcement that is occurring. So a couple things that are happening. Number one, there's increased enforcement by both the commission as well as the AG's office, the Attorney General's office in New York. And remember, New York Attorney General has jurisdiction both over New York City, but as well as New York Article 23A of the Corrections Law, right? And so that is a separate and distinct requirement that is going to apply to everyone in New York. It's 8 factors that are very similar to the EEOC individualized assessment factors. But we are seeing the AG's office really target companies who have operations in New York City and New York generally. So remember, the issue with New York City is very, very broad. It is a ban the box statute, but you cannot mention criminal history anywhere until after conditional offer. What this means is that you can't mention it in job postings, in applications, in interviews. I just had a conversation with a client yesterday wherein we talked about the fact that at the bottom of some applications, at the bottom of some job postings that they actually weren't really even necessarily aware of because they were on like third-party recruitment sites. There was language that basically said, your candidacy will be subject to successful completion of a background check. Well, the New York Fair Chance Act regulations and interpretations have said that is a violation of the act. So you want to be really careful about your job postings. And specifically, if you have job postings that are evergreen or that are applicable to someone that could be applying in New York City, you have to be really careful about that. The general best practice, again, without giving legal advice, is just strip anything in your job postings that says anything about a background check or criminal history, and have that after the conditional offer. Have that be in the conditional offer letter, right? Have that be in the disclosure form, separate and apart. But you need to be careful about that. The other thing in New York City is basically what the amendments really specifically talk about, and the Fair Chance Act talks about, is that they changed the definition of what a conditional offer really meant. And so what they're saying is they basically have said, listen, you as an employer have to get every single possible other limitation or screening before you look at criminal history. So if you're going to do drug testing, if you're going to do employment verification, education verification, if you're going to do some sort of pre-employment other testing, you need to do that before a conditional offer that is conditioned and can only be conditioned upon criminal history, which includes an MVR. And the MVR is a motor vehicle check. It's very interesting. We've had multiple conversations with the commission on this. Their view is that sex offender registry and criminal history and driving records are all criminal, whereas say sanctions watch list, global watch list, OFAC, AIG are non-criminal, and all of that has to be done before. So you either have the opportunity to do two separate background checks, right? One background check, one disclosure, one authorization, one form, and now analyze that, then do a conditional offer of employment, and then do the criminal history only background check. Or you ask for everything at once, and then you separate the information. But be very, very careful. If you're asking for everything at once and you mention criminal history in your disclosure form, you could potentially have a violation under the Fair Credit Reporting Act. This is tremendously challenging, and we are seeing a lot of investigation and litigation on this. So if you have any operations in New York or in New York City, you should really talk to your legal counsel to ensure that you understand what is happening, what your options are, where you may have risk, where you can mitigate your risk, and you really need to understand that. In addition to that, we've also heard now, and we know based on the amendments, that you, instead of not considering pending cases, you can consider pending cases, but they're still required to fill out that Fair Chance Act form. And basically you look at that pending record as if this was a conviction, it would be job related because X, Y, and Z, which is a little bit of a sea change from what it used to be. You now also have to consider the age of the person, and specifically whether the person was under 25 at the time that they committed the criminal history. And we are very clear now that the New York Fair Chance Act, we always knew it applied to applicants. Of course, it also applies to incumbent employees. So if you're doing recurrent checks or checks for promotion, and independent contractors. There is no question now that the New York Commission believes that this absolutely is going to apply to independent contractors as of that July 2021 date. So understand that. All right, we're going to go to the next topic, which is Philadelphia. Philadelphia, again, is another one that we now know. If you are doing business in Philadelphia, this fair chance, or this ban the box law, really now applies both to independent contractors and gig economy workers. If you have any gig workers or those types of workers, it also applies to applicants and incumbent employees. And there's more information about pending charges here. So you need to make sure that it's not only if you are looking at something in a pending charge, right? It's not an arrest, it's not a conviction. It's sort of in that middle ground. Somebody has been arrested, they've been charged, and that charge is still pending. There has not been an adjudication of guilt, for example, on that issue. It's still pending. So you need to evaluate that as if it was a conviction, is it job related specifically, and you need to have a written policy as well. We haven't seen so much litigation on Philadelphia, but again, it is a law, and so you need to make sure that if you have operations there, that you are aware of it. So what are we seeing on the horizon? And so we'll sort of wrap up a little bit here before we get to questions in terms of, we've seen this really big increase in ban the box legislation over the past 10 years. It has slowed a little bit, but again, there was just one that was passed in December. A lot of that often has to do with the economy. It also has to do with the administration and where we are from a political climate in terms of what ideology is being put forth and what agenda items in terms of, fair chance hiring, getting people back to work, for example, what's happening in terms of economic conditions when there's a recession, when there's not, how big is the job pool. What will be interesting to see in the next year is what happens with these ban the box laws, given everything that is going on with inflation slowing, with people getting back to work, with the pandemic sort of, I'll call it turning a corner, slightly at least. So it'll be interesting to see if we're going to see any more of those ban the box laws. What we are seeing is AI laws coming down the pike. What I mean by this is artificial intelligence laws, and specifically enforcement by the EEOC. They just came out with a pronouncement about artificial intelligence and hiring adjudication tools and guidance that potentially could be discriminatory. And really legislation in terms of, it's very, very broad, and it hasn't passed yet, but very, very broad, both in New York and DC that we're seeing, that is really focusing on tools that you may be utilizing as an employer through your background screening company, through your own ATS systems, through other systems, software programs that are using artificial intelligence that potentially could have a disparate impact on certain groups that then would be violative of any of these ban the box laws, some of the fair chance stuff, and Title VII of the 1964 Civil Rights Act, of course. So understand this as the next hot topic. I think we're going to see a lot of information on this this year. We've already seen some real movement, again, specifically in New York and Washington and other places as well. Unfortunately, we've seen more restrictions coming from courts restricting access to information. This one, I think the background screening industry is very, very focused on and has been monitoring these bills and trying to get education out to these courts so that they understand the true importance of having this information. But we are going to see more of that potentially. We're also seeing more enforcement actions by both the attorneys generals, by private litigants, and we're seeing what I will call highly technical claims. So claims that, may not ultimately, what we believe, not ultimately harm a consumer, but are very, very highly technical. So for example, like the disclosure claims, right? Did Did you have a sentence that was deemed to be extraneous on your disclosure form? And or did you have, dotted I's and crossed T's on your pre-adverse action letter that specifically told the person that they had a right to file an action with a certain local jurisdiction? Or, for example, in New York City, do you have something on your job announcement or job posting that could be at least interpreted to have a chilling effect to say that you're taking into account criminal history prior to going through the whole analysis and then doing a conditional offer of employment? So we're seeing these really hyper technical claims. Those are just a few. We're seeing many, many more as well. And then we're also seeing more focus by the regulators. So the Consumer Financial Protection Bureau and the Federal Trade Commission on enforcement. So both against employers and against background screening companies, specifically about accuracy of information. And the idea is that some of these agencies believe that employers are actually not doing the individualized assessment, are not looking at the background reports, are utilizing tools and resources like AI, and no one is actually doing that individualized assessment to see whether or not something is job related or not. We're seeing a lot of this on the use of credit. What I would tell you is if you are not running credit checks, don't start. But that'll be interesting because it's been sort of quiet in the world of credit reports, relatively speaking, in the last few years, and we're seeing a little bit of an uptick in that as well. So that's sort of the general theme of what's on the horizon in the next year or so. I will go ahead and turn it back over to Thomas to see if we've gotten any questions from the audience. If you do have questions, go ahead and put them in the chat right now. And then obviously this is my contact information. I'll be happy to assist if you have any other questions. Thomas?
Thank you so much. So Pam, want to be respectful of your time, but we do have a handful of questions here. I'm just going to try and fly through a couple of them. And if we're unable to answer your specific question today, we will reach back out to you in a couple of days with an answer from Pam. So again, are counties going to hide and restrict other data? Is that trend going to continue?
It's unclear, Thomas. I mean, it's possible. There definitely is a shift in terms of making information private. So I would say it's absolutely possible. We've definitely seen this shift towards restriction of information, which is why we're trying to get ahead of it, if you will. So unclear, but it's very possible.
Okay. Do you see employers asking candidates to get certified no record reports? Do you see many employers?
It's a little bit of a crapshoot. And the reason I say that is because I'm only aware of really one court system that is offered that. It could be that as court systems decide to restrict access to the information, that is an alternative, or that's an alternative that we may fall back on as an industry in trying to ask them to provide. I don't actually think a lot of employers are doing that unless they have a large population in that specific county in California, at least right now.
Gotcha. How big of a problem are negligent hiring claims?
Yeah, so the issue with negligent hiring and negligent retention claims are, thankfully, they are few and far between, but they have enormous impact, right? So they've got impact from a media standpoint. They also have impact from a cost standpoint. And when we're talking about negligent retention and negligent hiring claims, this is what normally happens. Employer hires someone because, and they run a background check, or they don't run a background check, right? Or they run a less than comprehensive background check. They hire a person and something bad happens. Let's say some awful violent crime happens to another employee by the employee that they hired. And so the negligent hiring claim is, unfortunately, oftentimes when someone is very, very badly injured, or a sexual assault, or deceased. And then what happens is a claim against the employer that says, you were negligent in the background check that you ran. You should have known. You should have done better. You should have done due diligence in a better way. And if you had, this terrible act would not have happened. And so it's generally what's called a negligence theory under the law, that there was a duty and the duty was breached, and that breach of that duty caused harm or injury. And so, as you can probably imagine, these are oftentimes few and far between, but they are exponential in terms of the potential damages and exposure from a media standpoint and from a fee standpoint. And so it's always really important to make sure that, why are we doing these background checks in the first place as employers? Obviously, we're doing it for the safety of our people, right? Safety of our employees, the safety of our customers. So having a comprehensive background check program wherein you're dotting your I's and crossing your T's, you're running, packages that are comprehensive. So a national criminal database, but with county level verifications, but also county level searches where you're, potentially running federal criminal searches, depending on all of the things of the type of business you're in, it's going to be really important.
Okay. As it becomes more common, should we start providing job analysis for job relatedness in our adverse action notices across the entire nation, or does that potentially just increase our risk?
Yeah, so I think there's sort of this is almost like a two-part question, right? Which I would say is, one, should you be doing that individualized assessment, job relatedness analysis, period? And then two, what should you be sharing with your candidate about that individualized assessment, job relatedness analysis? And so if you go back to the EEOC criminal history guidance, of course, the EEOC would say you should be doing that job related analysis and that individualized assessment analysis for everyone, right? And I would agree with that because it's going to, number one, you have to in certain jurisdictions. And number two, it's best practice under the EEOC criminal history guidance as well. So that's sort of this pocket. The secondary question, I think, which is really what was asked here is do you have to tell the person about that individualized assessment in your pre-adverse action letter or adverse action letter? And even if it's not required, should you sort of generally? And obviously the first answer to that question is, well, you got to figure out if it's required or not. So if you're in a jurisdiction, the ones that we specifically talked about today that requires that, then obviously you need to comply. I've had a lot of companies actually ask that question to me to say, well, shouldn't I just go ahead and have, that, San Francisco requires that I say the specific conviction, why I'm thinking about taking adverse action. Shouldn't I just go ahead and put that? And the answer is maybe. And the reason I say that is because sometimes it's not as simple as just the conviction. It may be a falsification issue on top of that. It may be multiple. It may be, well, yes, you have this conviction, but you also, have these other convictions that, one wouldn't take action, but, the compilation. And so, I think our general recommendation is you should always do the analysis, number one. And two, there's no reason not to share the reason why you're making this decision. But sometimes the more you share, the more somebody can argue that's the only reason. And if there are other reasons and you're not going to be able to put that into the letter, you may want to be cautious about that.
Okay. And then if I have an incumbent employee whose history we know about and we want to keep them, do I still need to complete the pre-adverse action every year?
No. The pre-adverse action you only have to send a pre-adverse action letter if you're thinking about taking adverse action on the person. So if you've hired the person and you know their criminal history and you're not going to take any adverse action, then the answer is no, you don't need to do anything like that.
Okay. And I heard you say if you're not doing credit checks, don't start. If they are doing credit checks, should they start or should they stop?
Yeah, so it's really dependent. And so I would say a couple things with regard to credit checks. So unlike the criminal history, there's no guidance from the EEOC. There's actually no guidance on the credit history that's been published really recently. There's, there's pre-employment selection criteria back from 1991. It's a long time ago now. But the issue with related to credit is sort of a similar issue of the idea of criminal history, right? Is the use of credit, or could the use of credit have some sort of disproportionate or disparate impact on certain minority groups? And so you want to be careful about that. So one, I would say if you're running credit, there are certain jurisdictions, there's about 10 laws that have specific prohibitions on when you're allowed to run credit and when you're not. There's multiple states, and then you've got New York City and Chicago, both have credit check laws. And basically it's you can't run credit unless you meet one of these exceptions. And so, Illinois' exceptions, frankly, are very, very huge and very, very broad, whereas some others like California are very, very narrow. So you need to make sure that you're allowed to run credit under that law. The other thing I would say is some of those laws require specific additional disclosure or additional authorization. So make sure that you're doing that as well. And then the third thing I would say is, what are you using the credit for? And do you care? So if you're running a credit check and never looking at it, then why would you be running the credit check? Because there's a lot of risk regarding that. Number two, I would certainly recommend taking a look at, what specific positions you are running credit for, because a credit check on a, entry level individual at a manufacturing facility may be not job related at all. Whereas, a credit check on someone in accounting or finance or an executive level position may absolutely be job related. I actually was lucky enough to testify at the EEOC hearing a number of years ago on the use of credit in employment. And so the argument against credit checks, right, from certain people that testified were, look, there's no indicia of the individual's propensity to engage in theft or fraud based on a credit check. And, I was testifying from the employer community, basically saying, look, someone who cannot manage their own finances perhaps may not have the judgment to manage a company's finances. And so really that's sort of why employers really run credit checks. But you certainly should limit the positions on whom you are running credit checks if you are running them, and just evaluate whether or not it's job related and whether it's necessary.
Okay, great. Well, Pam, I'm going to say thank you so much for your time today. Extremely impactful information. We appreciate having you today. And thank you to all of our attendees as well for joining us for this session. Thank you so much.
Thanks, everyone.
All right. Thank you. Bye-bye.
Cool. All right. Bye.